On July 14th, Senate Majority Leader Chuck Schumer presented a proposal for comprehensive cannabis reform called the Cannabis Administration and Opportunity Act. Currently in its draft state, Schumer and his team are taking commentary from lawmakers and the general public through September 1st. In this video, we will discuss the core components of the bill, lay out key points of interest for cannabis operators, and offer our thoughts on ways to strengthen the legislation. And finally, we'll provide a status update on the likelihood of the bill ever becoming law. So the topics we'll specifically cover today include breaking down key components of the Cannabis Administration and Opportunity Act, assessing where the Cannabis Administration and Opportunity Act stands today, and helping cannabis operators prepare for federal cannabis legalization. So before we dive in, please like this video and follow us for more cannabis news and updates. As always, the information contained in this presentation is meant for guidance purposes only, and not as professional legal or tax advice. Further, it does not give personalized legal, tax, investment, or any business advice in general. The first part of the CAOA addresses the federal decriminalization and support for a state's right to control cannabis. The key components of Section 101, descheduling cannabis. So remove cannabis from the Controlled Substance Act, establish a new federal definition of cannabis under the FDA, transfer primary regulatory authority of cannabis from the DEA to the FDA, TTB, and ATF. And upon transfer, these agencies would perform similar roles as those established for alcohol and tobacco. The good news here is subtle but important. The CAOA is suggesting cannabis should be descheduled and not rescheduled. This is important because many other legalization attempts have taken the half progress of rescheduling. Any real cannabis legalization effort must fully remove cannabis from the Controlled Substance Act. So we're very pleased Senator Schumer starts here. Reason for concern comes with the breakdown of federal agencies that will take over regulating cannabis. In that alphabet soup of agencies, there's likely to be confusion, bureaucracy, and other inefficiencies we've come to expect from the federal government. And while we're happy to see the DEA taken out of the picture, the ATF doesn't have the best reputation for nonviolent enforcement. We just hate to see the ATF turn into a smaller, meaner DEA junior. Key components of Section 111. Recognize state laws dictating cannabis. Allows states to create and enforce laws controlling the possession, production, and distribution of cannabis. Retains criminal penalties in circumstances of unlawful possession, production, distribution, or purchase of 10 pounds or more of cannabis in violation of federal or state law. Authorize regulations to track and trace the manufacture and transport of cannabis products, establish 21 years of age as a minimum age to produce cannabis, and authorizes the Secretary of Health and Human Services to continue to drug test for cannabis with federal employees. Our thoughts on this. So most of this is to be expected. The one eyesore is a mandate that federal employees will continue to test for cannabis use. This is simply absurd. Any regulation that punishes cannabis use where alcohol and tobacco use is tolerated is a backward policy that will be hard to change. We'll never have full recognition and normalization as long as the federal government considers cannabis a dangerous or illicit substance on any level. This is a backdoor way of continuing to punish cannabis users. In Section 2, Senator Schumer proposes a major federal investment in cannabis research. Section 201, Comptroller General for conducting cannabis research. Conduct an evaluation and submit a report within 2 years regarding the societal impact of legalization and in states with adult use of cannabis. Areas of research to include traffic-related deaths and injuries, hospitalizations, poison control center calls, violent crime rates, employment statistics, and rates of cannabis use. Section 202. HHS and NIH to conduct cannabis research. Annual report to Congress of the impacts of cannabis. Research a variety of topics including the effects of cannabis on the human brain, the impact on various health conditions, and identification of potential medical benefits and uses of cannabis. Section 203, DOT, HHS, and CDC to conduct cannabis research. HHS and CDC are to study public health prevention strategies, develop public education materials, and award up to 5 grants to states to collect data, raise awareness, and enhance the use of state data linkage systems with respect to impaired driving. DOT and HHS are to collect data on cannabis-impaired driving and continue research to enable the development of an impairment standard for driving under the influence of cannabis. Our thoughts. There hasn't been much industry or media attention on this section of the CAOA, but we think there is some low-key real value here. One of the great tragedies of the war on drugs and scheduling of cannabis is we've missed out on decades of valuable research regarding cannabis and its impact and benefits. With federal legalization, one of the biggest benefits will be federal money going into legitimate research about cannabis. Any good faith studies into these topics is likely to provide incontrovertible evidence that cannabis is nowhere near as dangerous as drug war propaganda would have you believe, and in fact has significant and previously untapped medical benefits. Having the federal government put their considerable resources behind scientific research into the impact of cannabis is likely to only produce positive outcomes, validating the safety and benefits of cannabis use. In this section, Senator Schumer lays out his plan for incorporating social equity and social justice goals into federal legalization. Section 301, Grant Programs to Address Impact of the War on Drugs, creates Community Reinvestment Grant Program to fund nonprofits that provide services to individuals adversely impacted by the war on drugs. Directs the Small Business Administration to create the Cannabis Opportunity Program, which will provide funding to eligible states and localities to provide SBA loans to small cannabis businesses owned by socially and economically disadvantaged individuals. Creates second SBA program, Equitable Licensing Grant Program, which will provide funding to eligible states and localities to implement cannabis licensing programs that minimize barriers for individuals adversely affected by the war on drugs. Section 304, Bureau of Labor Statistics, shall compile and publicize data on the demographics, age, race, educational attainment of business owners and employees in the cannabis industry. Decriminalization and expungement. Within 1 year of enactment, each federal district shall expunge any arrest and convictions, as well as juvenile delinquency for nonviolent federal cannabis offenses. Each individual will be notified of their expungement. Court shall also seal all records related to a conviction that has been expunged. An individual who received an expungement may treat the arrest, conviction, or adjudication as if it never occurred, and shall be immune from any civil or criminal penalties related to perjury, false statements, etc. No discrimination in provision of federal public benefits. Prohibits individuals from being denied any federal public benefit on the basis of use or possession of cannabis. Additionally, federal agencies are prohibited from using past or present cannabis use as a basis for denying or rescinding a security clearance. No adverse effect for purposes of immigration laws. Non-citizens cannot be denied any benefit or protection under immigration laws based on events relating to cannabis. Our thoughts. Cannabis advocates and proponents have always maintained that social justice issues must be at the heart of real reform. So we're glad to see federal guidance regarding expunging nonviolent cannabis convictions. That and the descheduling are the two biggest keys to legalization, so we're relieved they are here. The only real question will be whether the proposed SBA programs will get the funding and support to be truly effective. After surviving over a year of pandemic economy without access to the same federal funding mainstream businesses had, clearing the path to future support is a major win for cannabis operators. Imposition of tax on cannabis products. This would impose an excise tax on cannabis products in a manner similar to the tax imposed on alcohol and tobacco. For year 5 and after, the Secretary sets a rate based on quantity sold or a milligram of THC in the case of a product other than flower. Rates are based on the prevailing price of cannabis sold in the U.S. in the prior year. Establishment and permitting. This requires any person selling cannabis products at wholesale to obtain a permit from the Treasury Department. Any person producing taxable cannabis products must obtain a Treasury Department permit and register for tax purposes. A producer of cannabis products would also be required to register with the FDA. Operations. This would establish operational rules for manufacturers of cannabis products similar to those for alcohol and tobacco. The Secretary of the Treasury would be authorized to enter facilities and inspect books and records of manufacturers of cannabis products, as well as require reporting and tax filing. Proprietors of cannabis manufacturing facilities would be required to maintain such facilities in a manner to prevent tax evasion or diversion. In addition, manufacturers are required to maintain a bond to ensure cannabis excise taxes are paid. Our thoughts. Previous legalization legislation, including the MORE Act, proposed federal excise taxes in the 5 to 8% range. The CAOA takes the excise tax level to 25% for large operations, with 12.5% being the max for operators under $20 million in revenue. While it is helpful to see that large multi-state operators will take the brunt of the federal excise tax, there will always be concerns on how federal taxes will compound with existing state and local tax regimens. Additionally, it is no surprise that the feds want to get into the cannabis licensing and regulations game. It is just unfortunate that another level of licensing and regulatory bureaucracy is likely to be layered over the already stringent state and local regs. As we've discussed in other videos, the IRS has made a side hustle out of auditing and issuing fines to cannabis operators. Now other agencies can get into the game, thereby increasing the burden and risk for cannabis operators. In some ways, this feels like an inevitable cost of business for federal legalization, but it is unfortunate nonetheless. In this section, the feds take big steps toward legitimizing a lot of cannabis products, specifically CBD. Section 501. Establish Center for Cannabis Products and FDA. The Center for Cannabis Products would regulate the cannabis aspect of all non-medicinal products containing cannabis. This new department would be responsible for establishing and implementing requirements related to establishment registration, product listings, good manufacturing practices, product standards, labeling, distribution, and recall. Key components for Section 505. Create legal pathway for CBD. This amends a definition of dietary supplement to remove the prohibition on marketing CBD as a dietary supplement. Clarifies that the FDA would have the ability to require safety-related labeling or packaging requirements if needed, and give the FDA the ability to take enforcement action against any non-compliant CBD-containing products. Provides FDA with more comprehensive enforcement tools over products marketed as dietary supplements that contain substances such as synthetic, i.e. non-hemp derived, cannabidiol. Key components for Section 112B. Establishes federal track and trace program. So this establishes federal track and trace regimen for cannabis products to prevent diversion as well as federal and state tax evasion. Requires manufacturers to place tracking on all products to monitor movement from production to sale. Requires certain enterprises to maintain records of transactions which would be available for inspection by federal and state agencies. Our thoughts? The good news is that the creation of a dedicated department in the FDA focused on CBD will certainly fast-track the assessment and regulation of CBD. Both good news and bad news comes for the track and trace system. Currently, each state has a different system, which creates significant confusion and difficulty for multi-state operators. The good news would be if the federal system was effective and replaced state-specific system. Bad news would be if the federal system existed on top of an already established state system and created more confusion and bureaucracy. The latter is more likely, but we are hoping the former comes true. As mentioned previously, the CAOA is still in the draft mode and getting public comments. Additionally, it is safe to assume a great many backroom discussions are shaping the legislation to appease special interest groups. While we still have a long way to go till this even gets debated on the Senate floor, we must comment that the odds of this legislation passing are currently very low. Senator Mitch McConnell, while a low-key hemp advocate, is no fan of cannabis legalization, so we have to assume a filibuster scenario. To overcome a filibuster, the Senate needs a supermajority vote in favor, that is, 67 out of 100 votes. The Senate is currently split 50-50 between Democrats and Republicans. As it stands now, Senator Schumer's first challenge is to earn the support of his fellow Democrats. Unfortunately, 2 Democratic senators have openly expressed opposition to the initiative: Senator Jeanne Shaheen of New Hampshire and Senator Jon Tester of Montana. However, all is not lost, as a decent number of Republican senators are either in states with legal adult use or medical programs, or some combination of states' rights, open market, or libertarian advocates. Currently, 36 states have legalized medical cannabis, including deep red states like Alabama and Oklahoma. If South Dakota's legalization measure finally reaches law, 2 more Republicans, including Minority Whip John Thune, Republican, South Dakota, join the list of potential GOP supporters. Cynthia Lummis, Republican, Wyoming, and Rand Paul, Republican, Kentucky, have already shown openness to descheduling cannabis under the Controlled Substance Act. In total, we figure there are roughly 15 Republican senators who can support legalization based purely on their state's cannabis policy. To gain this additional support from the Republicans, Schumer will likely have to make significant compromises on the bill's current draft. If Senator Schumer can coordinate bipartisan support, another issue remains. Upon the release of the CAOA draft, the White House and President Biden made a public statement that they are not in support of cannabis legalization. Biden has made noise in support of decriminalization, but apparently legalization is a bridge too far. So if a tie in the Senate comes to Vice President Kamala Harris, there's no guarantee we'll have their support. Longtime California operators are all too familiar with Harris's policy on cannabis. With all that said, we sadly must report our gut feeling about near-term legalization is not good. It is difficult to imagine Senator Schumer getting the support needed from the Senate. The good news is that if the Senate does somehow pass a bill, our odds are much better in the House. Unfortunately, we still think we are on a multi-year arc for legalization, not within the next couple months. Despite our taking a Debbie Downer stance on legalization, there are some things that cannabis business owners can do in the meantime. Firstly, federal legalization would necessarily involve repealing 280E, the much reviled part of the tax code that has been an obstacle for the cannabis industry and a massive revenue generator for the IRS and federal government as a whole. While that is good news in the long run, it does mean that in the meantime, cannabis operators must remain absolutely vigilant on accounting for cost of goods sold and maintaining documentation to protect against IRS audits. If it does ultimately pass, the Cannabis Administration and Opportunity Act will present enormous growth potential for cannabis businesses and MSOs. Even then, cannabis operations may still face unique obstacles when opening in or expanding to newly legal state markets. Regardless, you can start tackling some critical to-do list items now, like organizing all of your financial statements, forecasts, and projections to put yourself in the best possible position for expansion. These documents are not only necessary for evaluating the current financial status of your business, but are also essential for providing financial transparency and viability to investors and partners, raising funds, merging with and or acquiring other businesses, MSOs, vertical integration, etc., turning around your business and or selling your business in the future. Additionally, there's no better motivation to plan, prepare for, and get caught up on your taxes. When federal legalization occurs, it will break ground as the single greatest milestone in cannabis industry history. Our cannabis CPA team and financial professionals have years of experience supporting our clients in all areas of the business, from putting together airtight tax positions to helping them lower expenses, streamline processes, prepare their taxes, navigate audits, outsource their CFO, and ultimately grow and expand their businesses. So contact our team at GreenGrowth CPAs at 1-800-674-9050 or on our website at greengrowthcpas.com to learn more about how we can help. Thank you so much for your time. We hope this information has been helpful. If you have any questions or want more information, please leave us a comment below. And be sure to like this video and give us a follow to learn more about the cannabis industry.